All right, let's get started for this evening. So we're starting with Chapter 2. We're going to be talking about laws, rules, and regulations this evening. So we do have a lot of material that we're going to end up covering tonight. But this is the good stuff. This is the information before we begin getting into the main topics of the forms, the promulgated forms that we have. So what we're going to start off with is tonight our learning objectives. The first one is we're going to discuss the role that the Real Estate License Act, and if you want to put kind of in quotation marks, it's called TRELA, T-R-E-L-A, TRELA. We'll discuss the role that TRELA plays in the use of promulgated forms. We'll also describe the unauthorized practice of law and how to avoid it. And then we'll also describe the composition and duties of the broker-lawyer committee. Further, we're going to also this evening, we're going to recall how many TREC forms there are and identify whether a TREC form is a promulgated contract, addenda, amendment, resale certificate, notice, consumer disclosure, or if it is an approved option voluntary use form. And those are going to be key there as well, because we want to make certain that we do have all of these different forms. Further, we're going to describe the proper procedure for presenting offers, as well as when you get multiple offers, and also identify when the offer becomes a contract. Okay, so just like in almost every course that we're going to cover, we're going to continue to keep coming back to this TRELA. Okay, almost every single slide deals with TRELA. Okay, so TRELA, of course, is the Texas Real Estate License Act, and it is administered by the Texas Real Estate Commission, which is the TREC that we call in everyday language. Okay? So, exactly. Exactly. Mr. Stahl made a very good point. He said on his test when he took it, they actually asked who administers TRELA, and as you can see here, it is the Texas Real Estate Commission. Okay. Now, on the exam, a lot of times on the exam, they're not going to put Texas Real Estate Commission. They're going to put TREC, TRELA. They'll come up with TALCB. There's a lot of them that they'll come up with, but when we're talking about administering the act, it was TREC. Now, the rules regarding the contracts, understand in this situation, the rules that regard these particular contracts are going to be discussed as well within TRELA. Now, the key and most important aspect in this one that you need to be aware of is that TRELA actually created TREC, which then enforces it. So the act created TREC, which then in turn, TREC now enforces TRELA. Okay, so it's kind of like a circular process here. Now, when we are talking about forms, okay, we're going into this and we're discussing forms and talking about theories and stuff like that, we do use promulgated forms. Now, a lot of people are like, why do I need to know promulgated? What's promulgated? Well, promulgated is basically a fancy word for what, Mr. Grossman?
Standardized.
Standardized. It's a nice fancy word for standardized forms. Okay, but again, if you see the word promulgated or standardized, they're primarily the exact same thing. Okay, now, very important, you have to understand that you have to use the most current version. Okay, you cannot use an outdated version. It will not end up, it will not basically suffice. You have to use the most current version. Okay, so if y'all were in my previous lecture, the previous class, we ended up, what did we find out, Mr. Eugene and Miss Linda, when we pulled up a form on off their website, off the TREC's website? What did we see? Do you remember what happened? One of the forms on TREC's website was what, Mr. Grossman?
Not up to date.
It was outdated. It was an outdated form. Okay? So in that situation there can be situations where even on TREC's website, it's outdated. And if it's outdated and you use it, guess what? You can get fined. You can get penalized. Your license could be revoked or suspended. So in those situations, it's imperative that you make certain that you're using the most current forms.
Well, how do you know it's an outdated form?
Well, that's a good question. How do you know if it's an outdated form? Well, let's pull it up real quick. You go to TREC's website. You go right down here to contact or contracts. And what you'll end up doing is, I can't remember which one we used last time or what it was, but to tell the most effective date or the most current date, you look at this date right here. You see that right up here? That is going to end up being the most current date. Now, when TREC updates a form, TREC will send an email out to everybody that has a license. And they'll say, we're updating the 1 to 4 family contract. And so pursuant to this, if they update it, so how you can check to make sure these match, you look at this date right here, okay? And then you match it to this date right here. If they don't match, then what ends up happening is you're using an outdated form.
So what do you do if you got to have a form?
If it is, now that's the thing. If you are working for a broker, your broker pays for a platform, a software program that ends up, keeps these forms up to date, okay? But there are some mom and pop brokerages where there's just a one-man show or one-woman show, and what ends up happening is it's a one-man or one-woman show, and they don't have the funds to utilize, say, zip forms or another type like doc loop or something to that nature. Well, if they don't have it, they make us say, we just pull all our stuff off of here, okay? That can end up, that can be problematic, okay? Because what happens is, this, while it's a nice website, is not a reason, say Mr. Stahl goes and he works for, say, me, and I'm a one-man show, it's me and him only, okay? Well, I can't afford zip forms or whatever, so I just use this, and I say just use this, and he uses an outdated form. Travis can't come back and say, well, I got it off your website, because this is basically classified as information purposes only, okay? Information purposes only. It is not meant to turn around and be a catch-all, okay? So again, it's very important that whatever you see on this website here that's showing, this is only an informational website. Everything that's attached here is informational, okay? Now, when they change the contract date, Mr. Eugene, I'll ask you this. When they change the contract date, do you think that they send it in bold letters and screaming and hollering, we're changing contracts and this is the date?
No, I don't think so.
No. Guess what it's going to look like? It's going to look just like your average spam that you get in your spam folder. Okay? So again, very important when you're dealing with this that you understand that when you're going through these contracts that you're using the most current version. Now, how do you know you're using the most current version? Well, let's think about it. How do I know I'm using the most current version? Well, the fact of the matter is that most of the time, they're going to change it right here, okay? They will change it right here. When you're using your forms, they need to match, okay? If this date does not match to the other date, you need to talk to your broker. And you need to say, hey, there's an issue. Can you look into it? And you need to get it resolved, okay? So again, if you have time, I can't remember what form it was when we did it.
Here's one of the ones at the bottom, like an addendum one or something.
I can't remember. I think it might have been. Yeah, it was this one. There we go. Addendum concerning right to terminate due to lender's appraisal. Mr. Jarrett, what date does that say, sir? March 1st, 2000 what?
March 1st, 2019.
2019. There you go. So in that situation is, this says March 1st, we open it up, and look at this date. 11/15/2018. Smart move to use that form? No. You use that form, and it's been updated, you can get in trouble. Okay? So it's imperative in these situations that you double check. Okay, you double check your forms. So if you ever get bored one day And you're like, I just want to get on Trek's website and act like a police officer and go through and report them for everything. There's a ton of forms, and here's your effective dates. And if they don't match, write a list and send it over to Trek if you want to. It's up to you. But I don't have time to do that, so I'm not going to end up using that. I pay for a platform, and if the platform's wrong, I can go back after the platform, not after myself. You see what I'm saying? Okay? So I'm just going to minimize that because we're going to use that a lot tonight. All right. So we got to use the most current version. Now, these, if you want to kind of put underneath that, when we're talking about most current version, if on the second bullet you want to put the exceptions, if you want to say must use unless, and then put quote unquote or parentheses, exceptions to the rule, these are the exceptions to the rule. Okay? These are all the exceptions to the rule. So, the very first one, licensees function solely as the principal. If, for example, say that Mr. Keith, he wants to sell his own property, and Mr. Keith goes over and sells his property, well, Miss Linda, do you think Mr. Keith needs to use the promulgated forms? He's selling his own property.
He's selling his own property?
He's selling his own properties. Does he need to use the promulgated forms? What's this first bullet say? If the licensee functions as their sole principal, last night we said principal is normally the seller, could be a buyer, but if the principal is a seller, do we end up in a situation, does that seller have to use the form? No. No. If a licensee functions solely as the principal, they do not have to use the form. Okay? They don't have to use it. If the U.S. government is involved in a transaction, say the government's selling something to you, Mr. Stahl, and you're buying it. The U.S. government's selling it to you, then they may require certain forms. Trek's form's not going to apply because we're talking at a federal level, not a state level. Okay? If the principal has provided and requires use of another contract, if, for example, that we go over here in this particular situation and we go and say, for example, that Mr. Grossman is selling his own property. Mr. Grossman is selling his property. Well, not selling his property. He's selling, say he's selling Jarek's property here. Jarek, he's selling your property. And Jarek tells you, Mr. Grossman, here's the contract that I want to use, sir. If your principal tells you that you have to use a certain form, you've got to use that form. Okay? There's no ifs, ands, buts to that. Now, question comes back to this situation. What happens, though, if we end up, Mr. Jarek goes over, and Mr. Jarek, he just says, Mr. Grossman, here's a piece of paper that I just wrote. I sell my property to so-and-so. That's all it is. It just has one sentence or two sentences on it. Is that valid? Technically, yeah. Because the seller, the principal, has stated that they're going to require the use of that form, that contract. Okay? So in that particular situation is, you're going to see that that contract is going to end up being required. Okay? If there's no contract that has been promulgated for specific use, and the licensee uses the contract prepared by an attorney or the broker-lawyer committee, then of course you can do it. Okay? But again, these are 4 of the methods for you to end up getting out of the contract. Does that make sense? Okay? So these are 4 functions, these are 4 exceptions to the rule when it comes down to basically practicing real estate. These are exceptions to the rule. Now let me say this. If you ever are in a situation where one of these might come up as an issue, you better let your broker know. Your broker needs to know that. Because you don't need to just go out and pull forms and say, oh yeah, I can do that type of contract. Or, oh yeah, I can do this type of thing. No, you don't do that. You need to make certain that your broker is aware of those issues. Okay? We need to make certain that our broker is aware so that the broker can advise you properly in regards to how it needs to end up being functioned. Now, we're going to jump into Trek Rule 537.11. Okay, very, very important rule. Very important rule here. Okay. The things that we're talking about tonight is focusing upon laws, rules, and regulations. Okay. One of the biggest rules that is not often intentionally done, but accidentally done, is practicing law without a license. Okay. And you're going to say, how do you accidentally practice law without a license? Pretty simple. Okay. A licensee, when we're talking licensee, when you see that word, just assume real estate agent. Okay. But also don't just assume agent, it's a broker too. Okay. So when we talk agent, we're talking about a broker. When we're talking licensees, we're talking about everybody. Anybody that has a license, that's what it's going to apply to. Okay. So a licensee may not, number one, practice law. Just because, say for example, Mr. Jacob, he may know what deed needs to be completed or what type of form needs to be filed, he cannot tell a client what to do. Practicing law without a license. Okay? We have to make certain. Now, it's one thing if it's your own property and you're transferring it and you know what you're doing, that's fine. It's your own property. You're not harming another person. But if Mr. Jacob came in, Mr. Stahl, and he's giving you advice and says you need to complete this deed, and it's wrong, he can be not only sued by you for giving bad advice, but he can be sued for practicing law without a license. Okay? You also cannot offer, give, or attempt to give legal advice directly or indirectly. Okay? You may end up thinking, say for example, that Mr. Eugene, he goes over, and Mr. Stahl, you come in and you're like, Mr. Eugene, you sell a lot of properties. What exactly do you end up, what do you do? What exactly are you doing? What's your forms, or what are you doing? And he says, oh, I can't tell you that. You know, I don't want to get in trouble, Mr. Stahl. But here's the forms that I use. He may have not actually offered or given advice, but he did indirectly give advice, because what did he do when he slid it over to you, Mr. Stahl? What is he implying?
Those are the forms.
That those are the forms. So while he may think that he's being slick, is he really being slick? No. He's actually ending up putting himself in a very bad position. Okay? So again, extremely important that you understand those differences. You also have to give advice or opinions, or cannot give advice or opinions, as to the legal effect of any contract or other such instruments which may affect the title to real estate. You are not a title abstractor. You do not have the abilities to tell if a title is good or bad. You do not advise a client to the status of their title. It's not your job. That is what a title abstract is for. Okay? Your job is to do what? What's your job to end up doing, Miss Linda? If you're a licensed real estate agent, what's your job? To go give legal advice?
No.
To go give title advice?
No.
To give financial advice?
No.
Tax advice?
No.
Sell a home?
Sell home?
Sell a home. I can sell a home, but that's it. That's my duty. That's my job. My job is to sell a home. My job is not to do what? To go over and give advice, legal, financial, tax, or title. Okay? We also, in the same situation, do not want to give opinions concerning the status or validity of the title to real estate, or attempt to prevent, or in any manner whatsoever, discourage any principal to a real estate transaction from employing a lawyer. You'd probably be like, why is the last one important? Well, let's think about this. Most real estate agents don't want to employ a lawyer, or don't want you to employ a lawyer. For what reason? Why do you think Mr. Stahl, Miss Linda, would not want you to end up employing a lawyer in a real estate transaction?
Find out something you might not need to know.
Not so much that, not finding out stuff. Key thing is this: how does a lawyer get paid most of the time? Off the transaction. If you go over and go contact Mr. Eugene, your attorney, okay? You go contact Mr. Eugene as an attorney, and you say, Mr. Eugene, these are the forms that Travis has ended up, that he's drafted, and our forms are ending up promulgated, they're standardized forms. What ends up happening here? Well, think about it. If my form, Miss Linda, is just a promulgated standard everyday form, what's Mr. Eugene going to say about that form? What do you think he's going to say, Jared? It's just an everyday copy. You just copy it, keep using it over and over.
It's not good enough.
It's not good enough, right?
Me right one.
Let me write one, because what about if this situation happens? Or what if this happens? Or what if that happens? Or what if this? Or what if that? Or what if, what if, what if, what if? And what ends up happening in this situation is what? We turn into the lawyer stealing the transaction from the real estate agent. And then the real estate agent is like, well, I got screwed once. I'm never going to get screwed again. So I'm not going to let this happen to me. Okay? So in the situation is that we're going to have to make certain that as we're doing these things, we have to make certain that we're aware of these different elements. Okay? We have to make certain that we are preparing things and that we are prepared for the bigger picture. Okay? Your client has a right. Your client has a right to go seek legal counsel. If you go over and you stop your client from seeking legal counsel, imagine when you're there in front of a judge and the opposing counsel says, well, Your Honor, Mr. Stahl over there, he refused to let his client, Miss Linda, seek counsel. And because of that, this whole issue happened. So it's all Mr. Stahl's fault. Okay? Do you want to be in that boat? No. Nobody wants to be in that boat. I don't want to be in that boat. Okay? So in that situation is we don't want to put ourselves in a bind. If your client says, I want to speak to an attorney, what do you think the best bet is? What do you think you should do, Travis? Well, let them do it. But what should you do so you don't lose the deal? Go with them. Go with them. If they want to seek, if Miss Linda says, I want to go talk to Attorney Eugene, your response needs to be, okay, when do you want to go? And if she says, well, I'm going to go by myself. No. I'll schedule it for you. I'll schedule the meeting for you. Let's go. And you go sit down and you sit there. Because let me tell you, if Mr. Eugene is meeting with your client individually, he has a better chance of doing what to the client, Mr. Grossman? To stealing them, right? He has a better idea to steal them. But if Mr. Eugene, you're sitting there with Mr. Travis and Miss Linda, and Mr. Travis scheduled the appointment, and Mr. Travis did all the work, you gonna be able to steal them?
Nope.
You're gonna have to use Mr. Travis, and you're gonna have to sit there. Guys, there's been times at myself that this is what happens. I've seen over time. A lot of real estate agents, they get their real estate license. They got their license and they think, well, I got the license, I got the client. They signed a contract with me, they can't go nowhere. They're mine, so I'm just not even going to pay attention to them. Not even going to pay attention to Mr. Eugene. And I trust my clients. Don't ever trust your clients, okay? Don't ever trust your clients. Your clients can tell you one thing and everything, but guys and gals have been in this industry long enough, your clients are the ones that are the quickest ones to throw you to the curb. Quickest ones. Oh, what, Jared? If I get rid of Travis, you're going to give me $10,000 in bonus or incentives on building the house? Heck yeah, bye, Travis. That's what happens. But if Travis is sitting there, Mr. Jarrett, are you going to offer that incentive in front of him? Or are you going to say right in front of Travis, hey, fire Travis and use me and I'll give you $10,000. You gonna say that? Uh-huh. You ain't gonna say that. You're gonna keep your mouth shut, right?
Yeah.
So the key thing here is in that situation is that you have to understand it is your duty. If you're an agent, it's like you going to court. How many of you feel comfortable about this? Imagine this, Mr. Jarrett. You go over here and you hire an attorney to represent you in a murder case. Okay? So you come in, you hire Mr. Grossman back there to go, and he's going to be your attorney. You get him $50,000. He's going to represent you in a murder case. You on the day of the trial walk in, you sit down, you're like, all right, I'm waiting for my attorney. And he no-shows. How do you feel about that? You'd be stuck, right? And next thing you know, you're hearing what? And you're walking off, right? The same concept applies, guys and gals, in these situations, is you have to be aware. You have to end up being aware that as a real estate agent, it is your duty. If you heard me there, it is your duty, not an option, not I do this if I want to. It is your duty to be with your client in any of the transaction. One of the key things I will tell you, and this you might want to quote me on this one. You want to lose your client? Say these words. Well, just drive around and look and let me know once you find something. Or go talk to that builder without me and call me if y'all come up with something. What's going to happen in those situations?
You're gonna lose your client.
You're going to lose your client. Because, see, your clients don't understand the laws. When we get into agency, you're going to see the importance here. You're going to see the importance. When you get into agency, what we're going to learn is your relationship, your fiduciary relationship. Okay? And so in that situation, you're going to learn the fiduciary duties. Okay? So what ends up happening is it is your duty to go with your client no matter what. No matter what. Throughout the whole contract, you have to represent them. Okay? You cannot in any shape or form end up stepping out. Okay? So say, for example here, that if in a situation, say that, for just hypothetical here, say, Jared, that you end up, that you're my real estate agent. Okay? You're my real estate agent. And I call you and I say, Jared, I want to go look at this property that Mr. Jacob has built. I'm going to go look at it. Okay? And I say, I'm going to go over there and look at it. You're like, yeah, Justin, just drive by there. You know, no big deal. Just drive by, see what you think. If you like the place, call me. I'll come let you in. Okay, I'm going to go look at it. Okay, so I'm going to go over here and look. Well, lo and behold, while I'm over there at the property, guess who I run into? Mr. Jacob. Okay, or Travis made another point, another agent. Could be another agent, could be Mr. Jacob, could be anybody. Run into him. Next thing you know, Mr. Jacob says, well, if you just come and use me, I'll give you some money back on sale. You don't even have to use Jared. Save yourself some money. And so I call you, Jared, or what normally happens, they don't even call you back. Okay, you call, and I don't even answer your phones no more. Stop answering your phone call. So in this situation, what happens is I go over and I say, you know what? I say, we go over here and we end up having in this situation, say that I go look at the property, what ends up happening is what? I go over and I have this whole thing. Here's the key thing here, is that I kicked you out and I'm making money off of this other deal. Guys, I want to give you a real quick, actual real life situation. This actually happened to me here in Bryan College Station. I had my clients with me. We went to look at a house to buy for lease. They were going to buy it and lease it. Okay. Walk in, look at the property. But before we went in, there was an agent in front of us. Okay. Agent finished, and etiquette is you let the agent finish, you walk out, or when they finish, you walk in. You see it, you switch, but you don't interrupt their showing. Okay, it's proper etiquette. So they finished showing. Then I ended up walking in. Okay, and while I was walking around the house, the other agent I noticed stayed in her car. They never left. Her client left, but she stayed in the car. It's like maybe she's on the phone, maybe she's making phone calls. Whoever knows. Okay. So I don't even pay attention. I don't even pay any attention or anything. So I'm in here just doing my own little thing and all, following along, doing my showing and all. And as they're finished, I always make it a policy of mine. When you're finished, let your clients leave. Okay, let my clients leave. And what I do is I walk around the house and turn off all the lights, secure the property, and make sure it's taken care of. Proper etiquette, right? So I went in, finished all my stuff, turned all the lights off and everything. And I ended up, my clients, I noticed when I was closing the last blind, that woman had got out of her car and went up to my clients. So I hurried up, locked the door, walked out. I said, "Can I help you?" And she's like, "Okay." And she's telling him, "No, we're good. Here's my card. Call me later." I walked up to my client and said, what did she give you? She gave me her card. I said, "Give me that." Took it, shredded that thing, and I threw it. I said, no. Even when you're with your clients, people try to steal your clients. You see a problem there, okay? So it is imperative as a real estate agent that you are watching. Guys and gals, I'm just going to tell you this. In this industry, it can be very cutthroat, period. That's all I got to say. It can be very cutthroat. But that also in the same situation does not mean that you don't do business. It just means you do what? You defend yourself. You put up precautions. When I'm with a client, I'm observing that client. And I also do this most of the time. I take somebody with me. Because here's what happens. If I have Mr. Stahl with me and we're showing Mr. Eugene and Miss Linda a house, if I'm the agent and Mr. Stahl is helping, assisting me with it, what happens? I'm watching them. When we're done with the showing, what can I end up doing? Mr. Stahl, can you walk out with Mr. Eugene and Miss Linda? I'm going to lock up real quick, and I'll be out there in just a minute. When he walks outside, and they walk out with him, if another agent presents themselves, what happens? What's Mr. Stahl going to say? "I'm a realtor. What can I help you with?" And they're going to be like, oh, well, I was just seeing what y'all thought about the house. And they'll walk off.
I had that with Brian.
You had that with Brian?
We had a showing once where the lady that they left and they stayed in their car, and then or I guess it was people coming in after us, so they were waiting outside. I went outside with the clients, but Brian locked up, and when I went outside, she then got out of her car real fast and came up to our clients.
Yep.
And then
Try to
basically saw that I was there too with my real estate shirt on and everything, and had the clipboard or whatever, and when I walked out too.
Yep.
She just turned around and went right back in her car and waited for both of us to come out, and actually all of us left, and then she got out with her clients. But like if I wasn't there, she was trying to jump out and go talk to them. Yeah.
Yep. And they will. They will end up. I always tell people, some realtors, not all, but some realtors are like buzzards. Okay? They are in the situation. They see Jarek, your client, here's Jarek over here sitting outside waiting for me to go lock up the house, and they're just those buzzards just circling around you. And they're waiting for the perfect time to do what? Snatch you. Okay? Same key thing in this situation. You got to protect your clients. You got to protect them from those people. There's many things, there's reasons that I spend time on this, is because of the fact is, while you cannot practice law, you're still held to the same fiduciary duty as an attorney. So while you can't practice law, you still have to end up, you still got to protect your client just like you were an attorney. Do you see what I'm saying? Your duty is still at the top. See, here's the thing that people forget. People seem to forget that they work for their client. Their client doesn't work for them. There are plenty of agents in this industry that's been in it 20 plus years, and they will tell their client, well, when it's basically good for me, I'll show you a house. Jarek, I'll show you a house when it fits around my schedule. I don't care about yours, it's my schedule. Okay? That's not how real estate works. Okay? Your schedule fits around their schedule, period. There's no ifs, ands, buts in it. Okay? Your schedule is to be around theirs. Now, it is fine, of course. People will say, well, wait a minute. What if my client keeps calling me at 1, 2 in the morning? What do you do there, Miss Linda? Client keeps calling you at 1, 2 in the morning. What do you need to do then?
I'll probably answer the phone and say, just, could we have this conversation in the morning?
So I have 2 that said they would answer the phone. Travis, would you answer the phone at 1 or 2 in the morning?
No.
No? Mr. Eugene? No? Mr. Grossman? No. Let me ask you, here's a question for those of you that do want to answer. What the heck's going to get done at 1 or 2 in the morning?
Nothing, and they're probably, inebriated or something.
That's right. They may be drunk. They may end up being on drugs, and they're high. There could be a lot of things. And if you remember from contracts that we talked last class, the person has to be competent. What happens, Miss Linda, if Jarek gets off a DJing at 1 or 2 in the morning, he's your client, and he's drunk, and he's high, and he calls you and he says, hey, Miss Linda, man, it has been a party. I've had so many beers tonight, and I'm high as a kite, but I decided I want to accept that offer. What do you do, Miss Linda?
You're breaking up. Oh, I can't hear you.
You're breaking up. Can't hear you. Guess what? Jarek, if you are, let's say you were that person, say you were drunk and high, you used to call Miss Linda and say you want to accept that offer, is that a valid acceptance? Think about it. Are you in your right mind? If you're drunk and high? No. So how do you know what you're doing? You don't. You don't. If at any point of the day, doesn't have to be, if any point of the day, you as an agent feel like your client is drunk or on drugs or something else, or just not mentally right, you need to stop everything, and you need to call your broker immediately, period. Because the fact of the matter is, we all know how alcohol, drugs, and all that works. What's it do? It's a temporary side effect on our body and on our mind. It eventually does what? Eventually does what, Miss Linda?
Destroys your brain.
No, it eventually fades away.
Oh,
You
yes.
come back to
Yes.
reality,
I was on your side.
okay? But you come back to reality. So, Jarek, what would you do if you ended up, when you got that offer, say Miss Linda sent it to you at 3 in the afternoon, and you ended up, it's 3 in the afternoon, and you get this offer from Miss Linda, and Miss Linda ends up, she says, well, Jarek, they want you to purchase their house for $300,000. You're like, what the heck are they thinking? No, my house is worth $400,000. So Miss Linda said, okay, well, he doesn't want to accept the offer, so, I'll call. In the morning, I'll call Travis back and tell Travis we're not going to accept the offer. And then at 2 in the morning, 3 in the morning, after you've drank a few drinks and smoked or whatever, and you call Miss Linda and say, hey, Miss Linda, I want to accept that offer now. What happens in this situation? You tell her that, she accepts it, she tells Travis, what ends up happening? What happens here? You're going to come back to later on in the day, right? After the alcohol wears off and all. And then you're going to call Miss Linda, say 10, 11 o'clock that morning, and tell her, all right, hey, Miss Linda, where are we at with that transaction with Travis? Well, we already accepted their offer. What are you talking about, accepting an offer? I wasn't, what, who, what, when? You see the problem here? Okay? All right, guys, give me just a second, please. Just a moment here. All right, so let's move on to the next slide here. Okay, so under Trek Rule 537.11. Now let me explain something here with this 531.711. On the exam, this is what they're going to quote. So you actually have to know that rule. All right? So you're going to be aware of that. Nothing in this section shall be deemed to limit the licensee's fiduciary obligation to disclose to the licensee's principals all pertinent facts which are within the knowledge of the licensee. That's a very, very, very important statute. Okay? Let's break it down for a minute. Nothing in this section, meaning nothing in this rule, shall be deemed to limit the licensee's fiduciary duty to disclose to the licensee's principals all pertinent facts which are within the knowledge of the licensee. That's a very, very detrimental thing. You know why? Because here's the thing. Say in this situation that Mr. Keith, for example, that Mr. Keith is a pest inspection person. He actually in his previous life he used to kill bugs. That's what he did. He did pest control. Okay, that was probably 10 years ago. He's now a real estate agent and he sells homes. And as he's going through a house that a buyer is purchasing, he notices in a couple of areas through the house that there's termite hose. My question to Mr. Keith is, Mr. Keith, do you have to disclose that to your buyer?
Yes, I would.
Is correct. Mr. Keith has to disclose that to his buyer. Because what did it say right here? That it does not limit the fiduciary obligation to disclose all pertinent facts, which is within the knowledge of the licensee. So even though he may no longer have his license, he may no longer have anything to do with it, it's been 10 years, it's been a decade ago, he still has the knowledge of what? Of what a termite possible infestation could be. Okay? So he has a duty, he has an obligation to tell his client, Miss Linda, looks like there's termites. See, the key thing here is just because you may end up not have that license anymore, you have that skill. You have that talent. Okay? That's why it's imperative that you have to fulfill your obligations. Period. No ifs, ands, buts about it. This one bullet is huge. It's huge. Because of the fact is if there is any type of, for example, Mr. Eugene has a background in electrician. He used to do electrician work. Okay? If Mr. Eugene notices that from a house to a garage, there's a long extension cord. Mr. Eugene, is that a concern?
Yes, it is.
Why is it a concern, Mr. Eugene?
It's a hazard.
It's a hazard. Why?
Because you're not careful, you can hit it just wrong or have a sharp instrument, cut it, it'll give you a good shock.
Could it kill you?
Oh, yes, it could. If it's
Man.
got the right amount of power, then it probably can.
That's right.
It'll give you a good jolt.
That's right. So in that situation, and I bring that up because I've seen it before. I was showing a house, and a person had ended up, they took an extension cord, plugged it into the back part of the house, and ran it. And we're talking like almost a 20-foot extension cord, ran it out to their shed so they had power in their shed. Not a good idea. Okay? I've seen also where they've had plugs for, those big plugs you put in for washers and dryers. I've seen those on extension cords ran into the house and plugged in. Okay?
Oh,
You do those things and you cut them, and it doesn't even have to be cut. what can happen after time? What happens to something that's external? What if it's an interior plug, for example? Say, for example, it's an interior extension cord, and you have it outside.
Ain't gonna last long.
It's not going to last long, and it's going to fray. And if it frays, what ends up happening? It can come apart, and you can touch it, and it can shock you, or it can kill you. Okay? So if you have knowledge of a particular thing, you are deemed to have that knowledge. Now, here's the best part, Miss Linda. You ready? Here's the best part. So your husband ends up, he's knowledgeable of this. Guess what this law also goes into? Knowledge of the licensee. Any pertinent facts which are within the knowledge of the licensee. What do you think a court of law is going to assume if your husband used to be an electrician? What are they going to assume, Miss Linda? That you know what?
That you're aware of the situation.
That you're aware of it too, even though you never helped a license. You see the problem here. So in these situations, you have to be aware that when we're doing these things, that your spouse could also, if they are in a situation where you would be aware of it, you have to disclose it. But what happens now, here's the biggest thing, what happens if y'all are showing a house, say, Miss Linda, you're showing a house to Mr. Grossman, and you're showing him this house, and you see that issue, but you know if you spot it to Mr. Grossman's going to bag out of the transaction. What happens? Do you not disclose it, Miss Linda?
I would tell him.
You would tell him, but you're going to lose the transaction.
Honesty is the best.
You have a duty. You never, if you did not tell him, whose interest are you putting ahead of his? Your own. That's why it's imperative that you make certain that you disclose things, even if it means you don't get a check. And I can tell you guys and gals, I'm going to tell you this. When you're in real estate and you've been in the real estate field for 6 months to a year and you've not made a transaction and you're about to say, screw it all, I quit. Okay? Let me tell you, I've been there. When I first got my license, I almost said, screw it all, I quit. I ain't making no sales. I'm out of this. And sure enough, when I got to that point, I got my first sale that went all the way through. This is an industry that you have to end up, you got to hold on. You got to hang tight. It will happen, and once it happens, it's smooth sailing. But you got to just get through it at the beginning. It's kind of like what I call it's an initiation, is what it is. A licensee may not undertake to draw or prepare documents fixing or defining the legal rights and the principles to a real estate transaction. You are not able to draft legal documents, period. Sorry. I have a background in law. I know what documents that need to end up being drafted in a real estate transaction. I know it. I know the deeds. I know all that stuff. I used to draft it when I worked for the law firm. I could probably spit out a general warranty deed to you in about 10 minutes. Okay? But I am not a licensed attorney in Texas. I cannot practice law in Texas. No matter if I know it, I cannot undertake or draw or prepare any documents that are for the benefits of legal rights. The key thing here is you have to be very careful when dealing with these. But what you need to know so far is that Trek Rule 531 or 37.11 basically applies to the application of representing anyone that is going to be UPL. And UPL equals unauthorized practice of law. You need to write that down. UPL means unauthorized practice of law. Very important on that one. Okay? They will utilize UPL. You need to be aware of it. When negotiating real estate transactions, the licensee may fill in forms for such transactions that are used exclusively forms which have been approved and promulgated by the commission. This key part right here basically states that you can only, as a real estate licensee, fill out standardized forms, period. Let me say that one more time. You can only fill out real estate forms that have been promulgated. That's it. You may not, in any shape or form, go draft a contract yourself. And this is a very key one here too. Let me actually go down to the next one real quick, then I'll give you that example. When filling out in a form authorized for use by this section, the licensee may only fill in the blanks provided and may not add to or strike matters from the form, except that the licensee shall add factual statements and business details as desired by the principals. I have a very hard time doing that bottom part. I've worked for law firms. I used to fill out and type up legal documents and all that stuff for the attorney I used to work for. I could type up a contract in a heartbeat. I know what to put in there. But sometimes when I'm filling out special provisions, I'll start typing and everything, and then when I get to that point where it says, but, or what do I say? Not but, it says, included but not entitled to blah, 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 blah. What I'm ending up doing is that's what I used to use in law. Or if I'll say including but not limited to blah, 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 what ends up happening there is, guess what? I'm practicing law, because those are legal words, okay? You have to, in these situations, you have to be very careful, okay? You have to be very careful when we are dealing with those situations, okay? We have to make certain that as we're going through these, that we are only utilizing and entering factual statements. Another thing you got to be very careful with when we're dealing with this is the part where we talked about strike matter. When you're in a contract, for example, let me pull something up real quick just as a hypothetical situation here. When you pull up a contract, you pull up a 1-to-4 family, and you see in this 1-to-4 family, you see all this pre-typed words. You see all these pre-typed words here? Say, Mr. Stahl, in this situation, I'm your client. And I say, Mr. Stahl, I don't want the, let's see here. I don't want my fireplace screen, my curtains and rods, blinds and window shades and drapery and rods. I don't want any of those items that are printed there. I want you to mark them out because I don't want them to convey. Can you just draw a line and initial?
I can either put it in exclusions, or I can advise you to go hire a lawyer to write your own contract.
Exactly.
Which is a lot of fun to do sometimes. People are like, I don't want that. Well, then go pay an attorney.
That's right. Exactly. You cannot mark through that in initial. Because when you mark through it, you're acting like an attorney. Okay? You have to leave what's printed. Cannot mark through it. Like Travis says, the proper way to do it is copy those words, put it down here in D in exclusions, and now it is excluded. Okay? But again, the key point is you do not just willy-nilly, I've had this before on offers from people before. They'll willy-nilly go through here and mark out stuff and initial here and go all over. Does not count. Does not count. Okay? Any of these words that are scratched out, that contract's void on its face because you're marking out words that are law. Okay? Now, here's a question. Here's a hypothetical because I've had this happen before. Mr. Darren, my client, he goes to gets consulted by Mr. Garrett, and he's an attorney. And Mr. Garrett tells Mr. Darren, we'll just mark through it and initial by it. What do you do in that situation, Mr. Stahl?
I'd probably tell him to do it.
The best thing to do in that situation is you need to end up, if the client comes in and says, Darren walks in and tells me, well, Mr. Garrett, my attorney, said mark through this, then your response needs to be, can you have Mr. Garrett send me an email that says that I need to do this so that I have proof that your attorney said that? And if your attorney said that and he sends it to me, and we mark through it in initial, now it's on who? It's on the attorney, not on me. Okay? Should you ever take your client at their word, Miss Linda? No. Why? Clients don't lie.
Clients are people. People are dumb.
Clients are people and people are dumb. You agree with that? Yeah. The key thing is yes, clients are people. Understand, it's easy. Anybody can say, well, I talked to my attorney and my attorney said do that. Okay, that's great. Can you just have them send me an email so that I can do that? You call their bluff. Because most attorneys know you don't mess with this, period. Okay? But if their attorney says it, then you got to do what their attorney says, but you need that documentation to support it. Okay? And let me tell you, if you go take this in with a marked deal title, do not be surprised if title's attorney doesn't call you and say, hey, Mr. Stahl, why did you mark this out? That's your prime thing. Not me. Here's the form from Mr. Garrett. Here's his information and all. Okay? So again, you want to protect yourself. That's that CYA provision there. Okay? All right. Now also, a licensee may not add to a promulgated contract form factual statements or business details for which a contract addendum, lease, or other form has been promulgated by the Commission for mandatory use. The key thing in this situation, and it's very important that you need to be aware of it, is that if there is a addendum, a lease, or other form that has been standardized by the Commission, you got to use it. Okay? For example, a client says to you, Jarek here, he tells you, he says, well, I want to purchase the property, but then I want to lease the property as well. So Jarek goes into special provisions and says, client will lease property. Is that acceptable? No, because why, Jarek? What do we already have promulgated? We have a lease. So you can't just willy-nilly go enter information if we already have the forms. Another thing you can't do, and I haven't said it yet, let's see here. Yeah, it's not in here just yet. But another thing you can't do, and majority of the things I'm talking to you about right now is talking about special provisions. It's just basically a small little paragraph that's blank that you can go enter whatever you want in there. The problem is you can't go in there and just willy-nilly type stuff in. You don't see what I'm saying? You have to end up, you gotta make certain that the stuff you're gonna put in there is business statements. They're factual statements and business details only, nothing else. Does that make sense? They cannot in any shape or form can you go in there and draft up stuff. Nor can you say, if Mr. Eugene does not buy my property, then I am entitled to $100 million from him. You can't put that in there because you're not an attorney. So you cannot, in this situation, special provisions, put remedies, is what we call it. You can't put solutions. They actually have to end up in the situation. They have to be just business details or factual statements. Something as simple as client is wishing to take the wash machine, or a client agrees to pay $50 to have the house cleaned. Simple stuff like that. When you type in special provisions, like my attorney always says, it should be no longer than one sentence. And I'm not talking about run-on sentence. Okay? I'm talking about one sentence, short, sweet, and concise. If Mr. Eugene, you're going to give $50 to Mr. Grossman to clean the house, then it just needs to say, seller to give $50 to buyer to clean house. Period. That's it. It doesn't need to be Mr. Eugene, comma, the seller, comma, is going to give Mr. Grossman, comma, the buyer, $50 to clean his house and deep clean it and also have it shampooed and washed and all of these things in this whole thing because we wants to give it to him. Too much information. Okay? Needs to be concise, to the point, be done. Okay? Because the key thing is, like I always tell people, the more words you put into a contract, the more it can be what? Construed against you in a court of law. You want to be short and sweet. Okay? It is not the practice of law as defined in this act for a real estate licensee to complete a contract form which is either promulgated by the commission or prepared by the committee and made available for trial use by the licensee with the consent of the commission. So what this basically says is it's okay, it's not the practice of law, okay, for a licensee to complete a contract form which has been promulgated. There's nothing against it for you to fill out a promulgated form. Now, where there's been a lot of issue is this, okay? And there's still debate on this. Some will argue that you can't interpret what's in the forms. So, for example, Mr. Grossman goes over and he gets his contract. He gets this contract and he's scrolling along and he gets down here to the most questioned one right here, number 8. This one right here is always questioned. So title, policy, and survey, paragraph 6, subchapter A, number 8. The standard printed exception as to the discrepancies, conflicts, shortages in area or boundary lines, encroachments or protrusions or overlapping improvements, blank will not be amended or deleted from the title policy, or will be amended to read shortages in area at the expense of either the buyer or the seller. And my question every single time from a client is, what does this mean? What's this mean? Your response to some people means, my thing is, I'm going to tell you exactly what it means because I know what it means. But if you don't know what it means, what's the proper response? What should you say? Miss Linda, you're my agent. I walk in, Miss Linda, what's a 6A8 mean? Can you explain that to me? Oh, what did you just say? Say that out loud.
Hang on, I'll call the attorney and let him tell you.
You need to go get an attorney to review it. But what were you going to say, Travis?
I was gonna say I'll ask the broker, I'll ask my broker, I'll ask
The
my
broker?
broker. I'll get back to you later. I'll ask
Okay.
my broker. I'll ask somebody else.
You say the same? Okay. Yes, you can talk to your broker. And most of the time, I can explain this because I've had training on this many, many times. But if you don't know, the worst thing you can do is,
Yes.
well, it means that the standard printed exceptions as to the discrepancies, conflicts, shortages in area or boundary lines, encroachments or protrusions or overlapping improvements will not be amended or deleted from the title policy, or will be amended to read shortages of area at the expense. That's what it means.
Thank you. I'm confused.
Now that you say it that way, it makes so much sense.
Right? Okay?
Did you understand that?
That's the worst thing that you can do. Well, that's what it means. The best thing is, yes, number one, contact your broker. Okay? So in that situation, we want to make certain on this situation that when we're going through this, that we want to ensure, okay, when we're doing this, we want to ensure in these situations that you are only giving, in that particular situation, we want to make certain that you're giving the good advice. You're not giving bad advice. Okay? So you want to make certain that whatever the advice you're given is going to be good. Now, if your broker doesn't know or your broker doesn't feel comfortable, then what Mr. Eugene just said is correct. Okay? So if Mr. Eugene said in that particular situation that I don't know and my broker is out of town, go consult with an attorney, that's right. But, Mr. Eugene, when you do that, what should you do?
Call
Go with them.
You call and you go with them.
Yeah.
You don't just leave them willy-nilly. Does that make sense? So in that situation, what's going to end up happening here is we want to make certain that we're going through and that we're only given the information here that's going to end up basically fulfilling the obligation to give the terms the best we can. But you may not always have the correct answer. Okay? Let me tell you, they're constantly changing things. They're constantly changing things. But again, understand, if you don't know, you talk to your broker. Your broker's not available. I will tell you this. Here's something that my agents probably don't know, because we haven't talked about this yet. But when you become an agent, you get access to this beautiful thing. You get access to this number right here. You call the Texas Realtor Legal Hotline, 1-800-873-9155. If your broker is unavailable, you call the legal hotline. But let me tell you something. I give everybody a heads up, okay? You never call this number unless you talk to your broker or somebody in your office has told you to call. Because here's what happens. If you end up in a situation, say that Mr. Grossman calls this phone number, what happens is, if you see, you don't have to wait for a callback on this one, okay? So that's a good thing. So now when you call the Realtor's Hotline, you don't have to wait for a callback. Used to, you called, and when you called, they'd say, that you'd answer, and they'd say, yes, may I ask who's calling? This is Stephen Grossman. Okay, and your license number? Okay, thank you, we'll have an attorney call you back. Click. Once that was done, right when that click happened, guess what happened? Stephen's broker got a contact that somebody contacted the legal hotline. And they will say, Stephen Grossman, license number, has contacted the Texas Legal Hotline. So again, while this is a great resource, you still talk to your broker before you go out and do it. Because what happens is that the brokerage, every time, here's the thing, this is what happens. TAR keeps a recording of this, of how many times it's called. Think about this. What if you're TAR and Mr. Stahl, you're the broker, and all of us in here that's listening and everybody here, we're your agents, and all of a sudden, Miss Linda calls, Mr. Eugene calls, Stephen calls, Jared calls, I call, Keith calls, Mr. Jacob calls, Garrett calls, everybody in here calls on the legal hotline. Everybody calls. What do you think TAR is thinking when they see over like 15 people calling from your brokerage?
My brokerage has a problem.
Yeah. Your broker got a problem, and you don't know what you're doing. So when it comes down to time for investigating firms, who are they coming after? They come to you, and they're going to come investigate. So therefore, it's imperative. While this form and this deal is very useful, if you're a small firm and you're working for a one-man show, say Travis is a one-man show. He doesn't have attorneys, brand new broker, he's just starting out. He doesn't have the funds to go hire an attorney on retainer. This is his way of continuing to operate in business. But let me tell you, I've called this number before. You know what I get most of the time when I call and I give them a hypothetical? Well, my client wants to do X, Y, and Z, and blah, 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 blah. Can we do that? Here's the deal. Well, it really just depends. Oh, okay. So what do I do? Well, we can't really give you legal advice because you're really not our client, but it just depends. Did that help you back there, Mr. Eugene?
Yeah.
Solve that problem, right?
Not hard.
Not hardly. Exactly. You have no idea what's just happened. So what happens in this particular situation is you've got to make certain when you're dealing with these things that you understand that this number is only utilized for an emergency. And most of the time, you're not going to get your question answered unless it's a basic question. Okay? Like, for example, I'll give you a hypothetical, Jared. Say, for example, your broker's out. And your broker ends up, you can't get a hold of your broker, and the office manager, Miss Linda, says, well, just call the legal hotline. It's fine. You know, I'll talk to Justin when he gets back. You could call this one and ask this question. My client wants to know, what does this mean? And they'll translate it for you. But if you start saying, well, which one should I check? Guess what they're going to tell you? Well, it depends. What does your client want to do? They can't give you the best answer because their job is only to explain to you the basics. Do you see what I'm saying? So in that situation is, while there is the legal hotline allowed, it's still, their duty is not to you, their duty is to the association. Do you see what I'm saying? So you have to understand when you're dealing with these situations that you got to remember who the duty is to. But there is a legal hotline that is available to help you in case you're in that type of situation. Okay? All right. Did we go through this one? Okay, making sure. All right, next one. Where it appears that prior to the execution of any such instrument, there are unusual matters, licensee shall advise the principals that each should consult a lawyer of the principal's choice before it's executing the same. Okay? So in this situation, what happens is prior to any execution of the instrument, there are unusual matters. The licensee shall advise the principals that each should consult their own attorneys. Okay? If you're working in a situation and the clients don't know what to do, they need to seek legal counsel. Now, of course, legal counsel wants to do what? When your client goes seeks legal counsel, they oftentimes are going to try to steal a transaction and do it themselves. Okay? But I always tell my clients this. Okay? This is what I always tell my clients. I don't mind you contacting an attorney. I can answer a majority of them because I've gone through most of this stuff and I've been doing this for over a decade. I kind of know how real estate works. Okay? But there will come a point in time that the broker doesn't know what to do. Been there, done that before. Okay? And what happens is if an agent comes in, if say that Darren walks into my office and says, hey, Justin, man, there's this situation, blah, 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 most unique situation here, what do I do? And he stumps the broker, it is the broker's duty, not the agent, not Darren. It is the broker's duty to reach out to his or her attorney and ask the attorney what to do. If your broker tells you, say I'm the broker and Darren's my agent, and I tell Darren, call my attorney, here's his name, here's his phone number, then that's fine. But you do not willy-nilly go around and have conversations. For example, this is a big one, guys and gals. This actually was a lawsuit that had occurred. Trek came in and investigated it and all. One agent ended up, this was a while back, I think 4 or 5 years ago, one agent a while back was sitting at a table. They all went as realtors, not at the same brokerage. They all just went to a group meeting, and they were sitting down talking about cases, about unique situations. Lo and behold, while they're talking about it, guess what happened? The client that they were talking about was sitting 2 tables behind them. They didn't use names. They didn't use the address of the property. They were talking hypothetical, but because the hypothetical was so close to the situation, the client knew they were talking about him. The client ended up contacting Trek. Trek investigated. Trek basically, I don't know what all happened with it, but something happened to them, and from what I heard, they lost their license. Because what happens is what stays within your brokerage is not to be discussed outside of your brokerage, period. Whatever transactions happens in your brokerage, you cannot go tell another agent. For example, Jared, let's say that you are working with me. You leave my firm and you go work with, say, Century 21 or Keller Williams or Caldwell Bank or wherever. You go to another firm. And you end up, you call me and you say, hey, man, how's it going, Justin? I'm like, oh, it's going good. Well, hey, I've got this unique situation. And here's the whole facts about the situation. What do? See, the problem is when I actually listen to you, I have violated just like you violated. The problem has to stay within your own firm. That's the problem with me being a teacher. Okay, I've had this happen before. I had to stop a student, the next student quickly in their, basically stop them in their tracks. One of my students from about 6 years ago contacted me and said, hey, Mr. Knowles, do you remember me? And I said, yeah. She said, I've got a unique situation. I ran it by my broker, but I don't agree with my broker. So this is what happened. And she gets ready to start telling me, and I said, whoa, I can't hear it. I am a real estate broker in the same town. I am, basically in this situation, I'm not teaching you. This is a real life situation. You have to follow what your broker says. Well, I don't agree with what my broker says. That's not my problem. That's not my problem. You have to follow what your broker says. And she said, well, I still think, and she started trying to give me, and I said, no, I cannot hear it. You tell me you're breaching confidentiality. You keep that to yourself. I cannot hear what you're saying. If you're one of my agents, we can talk. But if you're not one of my agents, you can't disclose that confidential information to me. Okay? She ended up, the key thing there was two things. She was violating, and number two, she was going behind her broker's back. Not a wise choice. Okay? Because what ends up happening is if that agent is going behind the broker's back, what do you think's happening in transactions? That agent's doing things behind their back. Okay? So you have to be very careful in those situations so that you make certain that you're following your rules, you're following the protocols. A licensee may not employ indirectly or directly a lawyer, nor pay for the services of a lawyer to represent any principal in a real estate transaction which the licensee is acting as an agent. You say, wait a minute, what? Wait a minute, what? A licensee, meaning a real estate agent or a broker, may not employ directly or indirectly a lawyer, nor pay for their services of a lawyer to represent any principal to a real estate transaction in which the licensee is acting as an agent. So, Jared, if you're just a nice guy and you have a friend, Mr. Eugene, back there who's an attorney, you're just a nice guy, you say, you know what, I'm going to take care of the legal costs for my clients. So I'm just going to pay Mr. Eugene to represent clients as I get them. Guess what? You're breaking the law. Can't do it. Why? Because when you are paying for an attorney, whose interest is Mr. Eugene's interest to? Me as your client or you? It's to you, not me. Because who are you getting your check from, Mr. Eugene? You get it from Jared up here. Okay? So in that situation, while it may be nice, still can't do it. A licensee shall advise the principals that the instrument they are about to execute is binding on them. When I get a final contract, I explain to them, the minute you sign this contract, and both people have signed, it's binding. Yeah, you can get out of the options if there's an option contract, but otherwise, you're stuck. And if you work with me, you'll know what I end up doing is I end up at the end, at the end of the option contract, there's a 10-day option. On the 9th day, I'm calling you, Jarek. I'm saying, all right, Jarek, we've done inspections, we've done everything. I want to explain something. If we go to the 10th day, on the 10th day, after that, you're locked into this contract, period. You understand? Do you want to proceed with purchasing this house? And if you say yes, then at that point, I'm going to say, understand, there's nothing else we can do. At this point, y'all, you can't just bag out. You're stuck in the sale. Are you willing to stay in the sale? Yes, I am. All right, I'm going to send you an email. I want you to see that you understand that you've done inspections, you've done your stuff, you're staying in this contract, and you agree. Yes, I did. Okay, and we're done. I have informed you. I have basically multiple times informed you, and you've not only been informed verbally, but in writing too. Does that make sense? That way, he can't come back and say, well, nobody told me that I can't get out of this contract. Yeah, you were told, and you yourself ignored it. Okay? Now, again, going back to UPL, unauthorized practice of law, of course, we've already seen it. It's prohibited by TRAILA. If you do it, you can end up, you can be suspended or you can be revoked. Okay? So in that situation, your license can end up being suspended or you can be revoked. So you will, when you get your real estate license, you're going to love this, but when you get your real estate license, you get to do number 3 here. When you get your license and you get sponsored by a broker, you will have to do a mandated 6-hour training on the Realtor Code of Ethics. 6 hours. Y'all are lucky. When I did it, it was 8 hours. You had to be there at 8 a.m. and you had to wait till 5 p.m.
Nobody's lucky. So lucky.
Yeah. And this was our lecturer when I did mine. When I had to do my Realtor Code of Ethics training. This was our lecturer. He spoke like this. That's how he talks. Okay? It's like a motor. That's how it was the whole time. Okay? But you have to end up in that situation. You got to go through the code of ethics, and you will go through that literally with a fine-tooth comb. The people that we have that goes through right now, wonderful, wonderful people that end up teaching the Realtor Code of Ethics. Okay? They know their stuff, and they're always there if you got questions to answer your questions. The licensee may give factual statements and business details and explain forms, but they may not give legal advice. Some of the common errors that we often see in the contracts when dealing with paragraph 11. Agents must take care when adding things to special provisions. You're going to hear that a lot. We're going to spend a lot of time. Special provisions, basically, it's this contract is contingent upon a satisfactory appraisal or satisfactory inspection, changes the buyer's rights in the contract, and may actually be unlawful practice of law. Simple things such as saying this contract is contingent upon a satisfactory appraisal or satisfactory inspection is unauthorized practice of law. But Mr. Nobles, how is that unauthorized practice of law? That's simple. That's a simple statement. You're changing the contract because my agent's here. Is there a spot for you to do inspections in the contract? Yeah, your option period. Is there a spot talking about appraisal? Yeah, the third-party financing addendum.
Still get 10 days to back out.
That's right. So my key thing here is it's already in there. Why are you changing the contract? You don't insert those things. It's already there. I always tell people this all the time. Special provisions, 90% of the time, should be blank. When I get a contract, 90% of the time it needs to say NA. What it needs to say. Okay? It does not need to actually have any type of comments or anything to that nature. So in that situation, understand that there should not end up being any type of changes. Okay? Another common error is to add things to special provisions that are already in the contract or an addendum. Can't tell you how many times that's happened. Okay? There's been situations before where they don't put it in there. They put errors or they fill in things that already are in the contract. If you change things that are in the contract, you can subject yourself to unauthorized practice of law. Simple little mistakes, simple little things can get you sued. Not something that I want any of y'all to be into. I don't want any of you to be sued. I don't want myself to be sued. But you need to be aware of these things. Broker-lawyer committee. We talked about this in the previous class. I want to test those of you that were in the class. What exactly does the broker-lawyer committee do, Mr. Eugene? What's their job?
Draft edit forms.
Well, that was easy. There we go, Mr. Eugene. Who promulgates those forms?
That's right.
Say that again, Miss Linda.
That's right.
Why doesn't the broker-lawyer committee promulgate the forms? If you notice here, my students aren't doing so well here. Okay. They are to end up, broker-lawyer committee, their job is to draft and edit forms. Okay? Treg approves and promulgates those forms. This one right here, bullet 3, extremely important right here. Extremely important. They will ask you, how many members? And of those members, how many come from each area? And my favorite of all is who are they appointed or approved by? I remember my test. Broker-lawyer committee has how many members? I was like, oh yeah, I got the easy one, 13. Went to 2 or 3 more questions. Who approves the 6 attorney members. I was like, ooh, is it Trek? I can't remember. Well, 6 members by the attorneys are approved by the State Bar of Texas. As I went on, who appoints them? The president of the State Bar. Okay, so you not only have to just know how many total, but how many each one comes from, who basically brings them in, and who appoints them. You see the problem there? See how it can be very complex. Okay, so there are 13 members to the broker lawyer committee. There are 6 members that are going to be brokers that are appointed by the commission. When we're talking about commission, we're talking about TREC. There are 6 members of the Texas or State Bar of Texas, and those, of course, are appointed by the president of the bar. And look at this, lo and behold, last person. One person, one public member, must be appointed by a governor. And that one public member cannot have any regulation or any relationship to anyone that is in the real estate industry. That person has to be completely independent of real estate altogether. So if your wife, son, daughter, spouse, whatever, has any relation to real estate, you can't be that one public member. Okay? It has to be a completely, basically unbiased individual. Now, the Texas Real Estate Commission has promulgated and approved these forms. This is what we're looking at here. There's been 6 promulgated contracts, 15 promulgated addendas, including 2 temporary leases, 1 promulgated amendment, 2 promulgated resale certificates, 1 promulgated notice, 2 promulgated consumer disclosures, and 7 approved forms, including 2 approved addendas. Now, do you think you need to know all of that? Not so much. You're going to need to know a concept of them, but you won't have to know it in extreme detail. Okay? You just need to know approximate numbers. Now, here's the best one. This is where my agents, my current agents, if you haven't got to do this, this is good information here. Because this will happen to you. This will happen. Unless your client decides to list their house for $800,000 and it's your trailer house. But in the situation is, Mr. Grossman, you look tired. I had to just throw that out there for you. So.
Yeah.
But okay, in this situation, when you are presenting offers, or if there's going to be multiple offers, there are certain situations you need to be aware of. The most important one is this first bullet. TREC rules call for an immediate presentation. Did you hear that again? TREC calls for immediate presentation. Can I do this, Mr. Travis? I am listing Mr. Jarrett's property here. Mr. Jarrett, he ends up, he works 8 to 5. I get a contract from Mr. Eugene, Miss Linda, and Mr. Grossman for his property. I get Mr. Eugene's at 9 a.m., I get Miss Linda's at 2 p.m., and I get Stefan's at 4:50. Do I have to end up giving those or sending them directly to Mr. Jarrett as they come in?
Yes.
Mr. Grossman, do you agree?
Yes.
Miss Linda, do you agree?
Yes.
Mr. Eugene, do you agree?
Yeah.
While it may sound wonderful,
It's not.
Yeah.
no, you do not have to send them as soon as they get them.
You can get multiple offers as long as you're doing it
It
within
has
a
to-
reasonable time based on.
That's the
Yeah.
key word, reasonable. While it says immediate presentation,
He's
it
not getting
doesn't
off work,
mean at
so-
the very second it comes in, I gotta send it to him.
Yeah. But
Okay.
he's not getting off work until whatever, so he's not going to see it.
That's right. I can hold them, but now let me ask you this now, Mr. Travis. So I'll get Mr. Eugene's at 9 a.m. on Monday. I get Miss Linda's at 4 o'clock on Wednesday, and I get Mr. Grossman's at Friday at 11:59 p.m. And I decide, well, I'll give them to him next Monday. Is that immediate?
No,
Why is that not immediate?
it's unreasonable to wait that long.
It's unreasonable because Mr. Jarrett gets off at 5 p.m. So why not? Now with Mr. Grossman, he gave me his at 11:59 p.m. Do I have to give it to him immediately at 8 a.m. the next morning? No. But I need to get it to him that next day. It has to be reasonable. Okay? That's the key thing. It has to be reasonable. So, a seller may accept the offer, reject the offer, counter the offer, or do nothing. Okay? Those are the options that the seller gets. When a buyer submits it, the buyer or the seller can either accept it, reject it, or counter it. Now, here's the problem. Now we're getting a little bit more complicated because we always like to make things complicated in real estate. When there are multiple offers, they must all be presented. Okay? So they must all be presented. So Mr. Jarrett, again, we're going to continue with that hypothetical. It's 8 to 5, he works. And what ends up happening is Mr. Eugene submitted his offer to me at 9 a.m. I send it over to you, Jarrett, at say 9 or at 5 p.m. So I send it over to you at 5 p.m. Miss Linda sends her offer the next day at 9 a.m. And Miss Linda ends up, I send it to you at 5 p.m. the following day. And then all of a sudden on Wednesday, okay, Mr. Stahl, Mr. Grossman, and Mr. Jacob, Mr. Keith, and everybody will get about 15 offers, and I throw them all at you. Okay, so you get about 20 offers, we say. Now here's the thing. Here's the thing that you need to be aware of. Okay, you have to present all the offers, but this is what your client's going to do. If your client has a lot of offers on the house, guess what? They're going to want to do what? They're going to go, well, they probably want to increase, but they probably have had this happen before. They're going to go over here in this situation where Jarrett's going to say to you, Mr. Stahl, we'll say you're the agent. Well, all right, Mr. Stahl, here's what I want to end up doing, man. Okay, here's what I want to do. I want to, on Stephens, I want to go back, I want to increase, or come back and counter him for $5,000. Well, on Miss Linda over there, I want to counter hers, and we cut down closing by 5 days. And on Mr. Eugene's, I want to counter and do, we're not going to give him the washer and dryer. I want you to counter all three of those for me. Okay? Should you do that? What do you think? You say no? Say yes or no. Should you do it?
I don't see why not.
You say why not?
If you're still in negotiations.
Here's the problem. Here's the problem. When you counter an offer,
Basically,
it's an offer.
acceptance.
It's not an acceptance, it's another offer.
Yeah.
So here's the thing. If you went out, you told well, everything that Jarrett said, told all three of them. Okay?
Yeah.
What if all three of them accept the terms?
Then you have to accept it all.
You got 3 accepted offers, and now your client has one house to sell to 3 people.
Yeah.
Okay? Your job, if you ever get multiple offers, your response needs to be this. This is the easiest response to do it. Okay? Easiest way to do this. You get multiple offers, you contact all the people, everybody, and you say, all of you that have ended up submitting offers, we appreciate the offers. At this time, we have multiple offers on the table. We are asking for your highest and best offer. We are accepting offers until 5 p.m. on Wednesday. Please submit them to us by that time. What happens is those of them that were already at their top dollar, they can't go any higher, they're going to drop out. You're going to weed out the dead weight, if you see what I'm saying. Okay? That's good in some situations. It can be bad in others. Because I've had this happen before where I had 4 offers on the table. My client was like, let's do highest and best. So I said, all right, call it all the people. And all 4 of them was like, well, screw you. We're taking our offers back. We're not getting into bidding more. And I lost all the offers. So it's a 50-50. It's a chance. But if you got 20 offers, it's worth it. Even if 4 or 5 bag out, you still got 15. Okay? But if you only got 2 or 3, it's a risk you take. It's a gamble. You need to make certain that you're doing it correctly. Now, what happens if your client just falls in love over this property? They just love this property. What happens? Well, if they're already under contract and your client has to have the house, you can submit a backup offer. Now, I'm going to tell you from experience, don't even waste your time. Okay? Because about 80 to 90% of the time, if that property is already under contract, it most likely is going under contract. Okay, it's going to be sold. Backup contracts are only if your client cannot find any other house and that is their dream house. The only problem is you have to still put up funds when you're in backup. So if you're under contract, you still got to put up the monies just like you were under contract in hopes that it goes and sells. But here's the thing, once you're in backup, you can't do anything until that contract sells or it bags out. So your client go finds another house, there's nothing they can end up doing. They're pretty much screwed. They're locked in until that contract sells. So if there's an extension and extension and extension and extension and extension, your client ain't buying no house until it sells. Okay? This bottom bullet, most important of them all. Cannot tell you how many times I've ran into this. Most agents, they either lose a deal or they get a deal and they're either extremely happy or they're extremely mad, okay, in real estate. But they forget about the other agent. They forget about the other agent. You have a duty to inform people of what's going on. You have a duty to tell them. If a client bags out, you got to tell the other agent. Another thing that you get that they don't put up here that you need to include is you need to also inform all other third parties. I have some people that they're afraid of telling the agent. They communicate with the agent all the time, but they can never tell the lender or the title company anything. They're up creek without paddle. Okay, so in that situation, understand you got to keep all parties involved in the transaction. Everybody needs to be involved in what's going on. When does the offer, do you have a question? When does the offer become a contract? Again, we talked about this before. It must be in writing, pursuant to what law? Remember what it was last night we talked about it. Statute of Frauds must be in writing. Okay? Statute of Frauds, contracts must be in writing. They must be signed and all changes initialed by the parties. So it has to be in writing, has to be signed, and all changes must be initialed. They must be complete agreement between the parties. There can't be any open-ended things. And the information that it has been signed must be communicated to the other party or the other party's agent. This is when you're officially, your offer is under contract. Guys, it is normal. It is normal for an offer to be submitted and it take a few days for them to sometimes get back to you. That's fine. That's normal. People do have jobs. People do have to look at options. There are things that are going on behind the scenes, but your agent should be following up with it. Your agent needs to be following up, making sure things are getting done. You don't want it to fall through the cracks. When presenting offers, it's important that things for agents to remember is that until a fully accepted contract occurs, the property is still for sale and any other offers must be presented. What's that say again, Mr. Eugene? Can you read that for me? First bullet here.
An important thing for agents to remember is that until a fully accepted contract occurs, the property is still for sale and any other offers must be presented.
That's correct. Until that contract is fully executed, it is still for sale. Even if you're in negotiations, it's still for sale. Okay? Very important. There is no such thing as almost sold. Okay? There is no such thing as almost sold. Oh yeah, Jarek, that property, it's almost sold, man. We're almost sold. No, there is no such thing as almost sold. It's not sold till that contract is, well, let's go right back here. It's sold, not really sold, but it's under contract when these things have occurred. Okay, these haven't occurred, it's still for sale. Period. There is no gray line. There's no fine line. These items aren't done, then it's for sale. It's not almost sold. Even after a contract is finalized, the seller may want to negotiate a backup contract. Again, not something that I recommend. Okay? It's not something that I recommend in this situation. Even though the contract is finalized, the seller may want to negotiate that backup contract. But again, you need to advise your clients the pros and cons of a backup contract. Okay? There are pros and cons to a backup contract. Okay? All right. That basically ends our lecture. Let me go back so you can see. Next class, guess what? Tomorrow, you're going to be happy. You ready? We're actually now starting to get into the content. We're really going to hop in and get into the contracts. So here's what I would like for you to end up doing. This is my little assignment for you this evening. Okay? My assignment this evening that I would like you to end up doing before tomorrow's class. Before tomorrow's class. I want you to end up reading these, not that fourth one, but right there. I want you to read those lines right there. That ain't long. That's simple. That's short. Okay? But I want you to read 1, 2, and 3. Because if you notice something here, what does the PowerPoint for tomorrow say? Parties, property, and money. What's this say? Parties, property, and what? Sales price, which is your money. Okay? So if you can't get it by now, what do you think we're covering tomorrow?
1, 2, 3.
Right here, 1, 2, 3. But we're going to go in detail. We're going to explain each one of these.
But that's, I'm sorry.
Yes, Miss Linda.
I see it's resales. Is there a different 1, 1, 2, and 4 family residential contract?
It would be a new home or new construction.
There's going to be different things, and we're going to talk about that tomorrow.
But we are doing the resale. So
But I want you to do the resale. But we're going to talk mainly, majority of this class is focused on this form. So starting tomorrow, we're technically getting in now to the contract. Now, there is not going to be a class where we're actually going to read this whole thing. We're not actually going to go through and read the whole thing. But you're going to read portions of it throughout this lecture, throughout this course. Does that make sense? You need to be aware of this. It's very important that you have a working knowledge of this material. Okay? So your homework assignment for this evening is to complete your unit quiz, do your discussion, and end up read paragraphs 1, 2, and 3 of the 1 to 4 family residential resale contract. Okay? It's going to be your homework assignment for this evening. Now, if you want to be proactive and get ahead of everybody in the class, you're that type of person, I like to get ahead of everybody, read the whole contract and take little dummy notes. My key thing here, if I were in this class, is I would actually print this off, this entire slide here, not slide, but this whole contract, and I would begin, starting tomorrow, taking notes, summarizing them. Because I'm going to tell you, at the end of this class, do not be surprised if I don't say, Mr. Jarrett, what is paragraph 3 in the 1 to 4 family? What does that do? Mr. Jarrett, what does paragraph 11 of the 1 to 4 family do? Mr. Garrett, what does paragraph 23 of the 1 to 4 family do? Do not be surprised if I don't do that, because on the test, on the licensing exam, that's what they do. They're going to ask you, what paragraph does this deal with? What paragraph does this deal with? You're going to have to know. Okay? There is not going to be any of this where you can just go and go through it. So it's best right now, if you want to be proactive and be ready for the licensing exam, to read through this and start getting a summary. Number 1, paragraph 1, parties. These are the people that are part of the contract. Number 2, property. This is the legal description and the things that transfer with the property. Number 3, the sales price. What they're purchasing, what amount they're putting down, what amount they're financing, what's the total price, so forth and so on. That's the easiest method for you to end up doing. Okay? Very, very important that you have an understanding and working knowledge of that. Okay? So, again, like I said, your assignments tonight, do your unit quiz, do your discussion, read through this. If you want to be proactive, read it all. Okay? Because you need to be aware of it so that you can explain to your clients. I will tell you, as a real estate broker and as an agent, there's many times that I have to sit down and explain each one of these different paragraphs. You need to be aware of it. Okay? All right. We're going to go ahead and stop there.